Okay, welcome everybody. I'm actually going to post in the chat right now. We have this advanced questions document, and for the first time ever, we don't have any advanced questions in this document, uh, which is fine because Meredith will still have plenty to say. But as you think of questions as we're going through this morning, you can still put them in that document, or feel free to just put them in the chat, and we'll be able to answer them live. So let me introduce our guest. While I'm doing that, if you could please put a quick introduction to yourself in the chat space, just kind of your name, your institution, or where you're from, that would be really great and would give us an idea of kind of who's in the room. Are you all librarians? Are you all somebody who's not a librarian, etc.? So while we put those intros in the chat, I'm going to introduce our guest, Meredith Jacob, as the director of the project on copyright and open licensing at the Program on Information Justice and Intellectual Property, sometimes abbreviated as PIGIP, at the American University Washington College of Law. Meredith is very nicely joining us on what I think might be a little vacation for her right now.
Yes.
So really appreciate you taking the time today. Doesn't have video, but that's okay. You can see her headshot there on Zoom, which is lovely and looks just like her. And I'm gonna let her introduce herself further as she likes, and then kind of take it away from there.
Thank you so much. Hi, all. I'm excited to join you this morning. I'm really sorry I'm not on video. The Wi-Fi here is not great, and I just kept dropping out. And so I'm on my phone for audio, but on the Zoom desktop so I can see chat questions and stuff like that. It's imperfect, but it is what we will have to do. And as Shanna said, I've done this a number of times talking to folks who are in the CC certificate to think through one of the important situations that you all are almost certainly going to face as you go out and do this work, which is how to answer people's questions in a way that gives them meaningful information and guidance, but avoids giving them legal advice. And it's a type of thing that I have worked on for the 15 years I've done this. And it's a thing that you'll have to work on because neither of us are in these situations these other people's lawyers. I am generally not other people's lawyers because even though I am a lawyer, I am not providing legal representation to people, right? When I talk to folks at open education meetings, when I talk to people in consultations about their works and projects, in all those situations, even though I'm an expert on copyright law and Creative Commons licensing, I'm not that person's legal representation. And so it's really important in those situations to provide legal information, to provide guidance about what other people are doing and about what practices seem to be working, but to not cross over that line into giving what we call fact-specific legal advice, which is where you tell me your specific problem and I go, well, this is legal and that's not, and you should do this, and then you won't get sued. And that's important because for two reasons. One is in most countries, if you're going to give people fact-specific legal advice, you need to be a lawyer. And the other is, if you do that, you need to be their lawyer and you need to have thought through all of the different sort of facets of the problem and the case, and you need to have that professional relationship. And we don't. And so it's an important thing to avoid giving legal advice. On the other hand, I would not have spent the last 15 years of my life doing this if I couldn't give people some meaningful legal information. That would have been a big waste of everybody's time. And so there is still a lot of useful stuff you can do when you're giving folks legal information. And that includes information about what you think the law is, right? So I could talk about fair use being a part of US copyright law, talk about how you evaluate fair use, talk about what cases have found, talk to folks about how Creative Commons licenses are often interpreted. And so I think you can tell people plenty of useful stuff, information about how you understand the law, information about similar practices without being like, yes, you can definitely do that. No, you can definitely not. I often give people information that says, I think that's a relatively low risk thing to do, right? Or I think that's a thing where I'd make sure I talk to someone really specifically. Like that's often the type of language I use. And the one thing I think is really important to think about here is telling someone not to do something is giving them advice just as much as telling them to do something. And I think out of well meaning caution, lots of folks, particularly folks working in education and libraries, have worked themselves around to this idea that if you tell someone, I don't know, I'm not sure, I think you shouldn't do it, that that isn't giving them advice in the way that if you said, I don't know, I'm not sure, I think you should, would feel like giving advice. And I would try to encourage people that while it's important to keep one step back from giving advice, it's also important not to lose sight of the fact that giving the advice not to do something is in fact also giving legal advice, and is giving legal advice that has a big systematic consequence, which is it prioritizes avoiding any sort of theoretical legal risk over all of the other sorts of mission risk to our pedagogical mission, risk to our educational mission, risk to our ethical mission of not doing things at all. And so I think balancing those two out, of not defaulting to hyper caution, but not giving sort of individualized advice. It's a hard thing to do, but I also think it's really doable. And I think that is through information, through examples, through talking through hypotheticals. And as we talk about a lot in the, sorry about that working noise outside. Is that really distracting to folks? I can try to find a different spot.
I'm not getting anything coming through. Zoom's doing a pretty good
Okay.
job of cutting out
There is
background
a
noise.
person using a saw about 50 meters from here, but as long as if it gets distracting, please jump in and let me know and I can find a different spot.
Well,
Um,
so far.
but it's really important, I think, to remember that the choices you made aren't just in a vacuum of like, how do I avoid all copyright risk, but it's how do I manage copyright risk, whether it's about fair use or about licensing, while still achieving my core mission, right? Because for everybody here, the best way to avoid any copyright risk about licensing, about misunderstanding the CC licenses, about misunderstanding fair use, would be to do nothing at all. That would be a very low risk position. You would have successfully avoided all risk if what you did was never give anybody any OER or ever use fair use or do any of this work. But that would be a pretty useless thing to do because you would have totally said, I'm going to take any tiny little bit of copyright risk and elevate that over my mission risk. In a similar way, like my favorite analogy, which Jen has probably heard 1,000 times by now, is that we let 12 and 13 and 14-year-olds use fire in chemistry class because we have decided that the small physical risk that every year, right, in the United States, every year, there must be one 13-year-old who sets another 13-year-old on fire in chemistry class, right? And we have just been like, sometimes you got to learn about, potential and thermal chemical energy, folks. And so that is what we shall do. And I think it's important to keep that in mind a little bit when we think about the law and about copyright, which is your goal cannot be risk minimization. Your goal has to be understanding the landscape you work in and making good, responsible choices. But to balance those against the risks that not doing that poses to your mission. Um, so I think that's really important. I also think figuring out as you do this work, what are some good resources to share? I'll make a plug here for the best practices in fair use, which we've worked on, which can help folks understand how to bring third-party materials into OER, but also other sort of things that help you provide hypotheticals or examples. You're like, this is a thing that we have that we use as guidance, or this is the way we structure our practice. Like giving those examples is a really good way to do that. So that's the sort of top-down theory about how to think about that. Wondering if folks have any questions about how to give information without giving advice. Any questions about that? One other thing, just to sort of go back, is when you're giving people legal information, particularly about, I think, things like copyright law and fair use, is it's often most effective for folks to focus on their pedagogy, right? Like when you're asking somebody, thinking through, is using this thing fair use, or is, am I doing this thing that is like complying with the license? Helping the person who's doing it think through and document the specifics of why they are doing whatever thing they're doing with the materials and how they're doing it, and not so much trying to get them to be um, sort of mini lawyers. So when we talk to folks about fair use, for example, it's really, really important for you to understand why you want to use that third party insert. Like, why is that a good example? Like, why should students critique it? Why do they need to select from these fields? Why should these be real world examples and not made up ones? That pedagogy is what makes your legal argument. And it's much more important to focus on that than it is to focus on trying to basically sort of be your own lawyer. Um, that's all a little bit abstract. So it's going to pause here and see if anybody had any questions or comments. One question I have, I guess, maybe to just sort of start the discussion is, are there situations here where anyone would be willing to unmute or hop in the chat and talk about a situation in which you were asked by a colleague whether or not they could do something, hey, do you think it's okay if I do this? Or do you think it's okay if I include that?
I
Or can
have
I remix
one.
these two things? Oh, great.
Okay, I was actually writing this in the chat. And as you're saying that, I prefaced it with I'm not a lawyer, I'm just a copyright nerd. But I wonder, and I'm hoping maybe I didn't like kind of do the tango of like, someone who isn't me might say, you know. Um, but yeah, so a faculty member who is in possession of unpublished writings from a locally well-known author, who has
Okay,
passed away, they wanted to do one of two things. One, they wanted to donate them to a university archives, or they wanted to publish it as a book. And I just said, if it was me and I wanted them to be, uh, at least handled by somebody in that field, the university archives might have somebody on staff that's like a scholarly communications librarian that might be able to give him guidance on that. But I told him I would, if I were in that position, I probably wouldn't try to publish it as a book just because even though the person has died, and I also, it's one of those sad things where they don't have a next of kin, they don't even have like a third cousin, where it's just still kind of in this estate limbo. And I just said, I that's probably not the route that I would go. Um, and so I hope I was elusive enough, but while still
sure,
giving good advice. But the other thing is this person had a representative that had their estate vested to them, but then they quit their job at that agency and went to England to go work for Oxford University. So it's kind of like, and they were not replying back to this person. So
sure.
yeah, so I mean, that's my situation. It was super weird, and I hope I did the right thing.
Yeah, I mean, I think there's probably no single one right and perfect thing, right? You could ask a couple different people. Um, so that's an interesting, pretty complicated question. And I think if I were asked that, there's a couple things that come up, and usually that's how these are going to go. There's not going to be. They'll usually be, uh, for lack of a more precise term, a couple different sort of areas of like lines of analysis, right? A couple different sliders, to use a sort of more analogy, right? Where you're like, well, this slider goes more towards, yeah, do it. And this slider goes more towards like, I don't know, maybe like be a little more specific. So the first, slider is that these are unpublished works. And so um you're you're like, well, okay, so the first question is like, are works that are unpublished treated the same? And that's like one question to look at. And then there's this question of like, there's no one to deal with here. So the question of published versus unpublished comes to a couple of different things, right? One is if you look at the law, it says that published works go into the public domain 120 years after creation, so longer, right? But then at the same time, there's this thing of unpublished works that generally unpublished works are not administered in the same way, right? They often end up being what we call orphan works. And so I think what you gave is an answer that focuses a lot on the sort of certainty question of like, if these were unpublished, they're not in the public domain yet, right? This person didn't die 120 years ago. And so they're not in the public domain, and so probably you shouldn't publish them. And that's one way to look at that. The other thing you could look at is, in fact, if this person has no known heirs and the person who is administering their work can't be contacted, then these often are they could be considered what we call orphan works, right? And so the way in which we think about publishing and sharing orphan works is a little bit different, because they're works that have, sort of passed out of the normal administration of copyright. There is no one to ask for permission. And so there is actually a best practices on fair use for digitizing and sharing orphan works that's also published at that CMS site that Shannon had put in the chat earlier. And that best practice for orphan works talks about thinking about when and how you could take something that is an orphan work that doesn't have a person actively administering it and publish it. And then I think the third point of like, yes, this is definitely a thing that could go to an archive is important to think about making sure that even if this person doesn't decide to publish, that they get those materials get to a place where they are administered. So there isn't one perfect answer. I might have gone a little bit more into the, like, these could be orphan, but it's certainly true. I think the core point here is you cannot, as a not lawyer, not her lawyer, you cannot tell this person, yes, definitely publish, or no, definitely don't. That ultimately that choice about what to do is going to have to be that person's, right? Because they could say, you know what, I think these letters are really important. I think the risk of anyone coming and suing me over this is basically zero, because I think there's no one around here. I don't think this person in the UK has any interest. I think I can do this, and I'm just gonna do it. That could be one person's risk tolerance. A different person could go, I don't want to have any hint that I'm doing something without clear permission. I'm not going to do that. And so I think the whole point is it's your job. Just give them the information and be like, you have to make this decision. What is your risk tolerance? And it has to be, what is personal risk tolerance? Maybe what your institutional risk tolerance is. What's your publisher's risk tolerance? Some publishers might be like, yes, fine, you can do that as long as you sign an indemnification. Other publishers might be like, no, we're never going to publish this thing if you don't have clear permissions. That's just a totally different choice, right? And you see those choices in the cases. One of the most famous cases in fair use is a case about a book that was published that was all Grateful Dead show posters. And they were like, look, we're documenting the history of this band and of the graphic style used. We're not using these posters for what they were originally for, which was publicizing these shows, right? These posters were created to publicize shows. We're talking about the history of the band. We don't need to pay for that, right? That's fair use. And in that case, it was upheld that it was fair use. So people do make those risk decisions, but that case was litigated. And for many, many people, and I think this is important to think through, where on the continuum of pushback are you willing to tolerate? So I personally think, and this is just my hot take, this is not me speaking in my professional capacity or me speaking for CC, and this is hard, and I know it's hard to say because I work in a law school, but people have to tolerate the possibility of a nasty note, of a cranky email saying that you have done something wrong a tiny bit more, because there is no amount of caution on earth that can prevent you from ever getting a cranky email from someone saying, hey, you're doing a wrong thing, you shouldn't do that. And that's certainly a risk, right? And then you just, so do I have the institution? Do I have someone else in my program who I could get down with me and say, yeah, so if you're thinking about the lowest level of consequence from doing something is the nasty note. It's the cranky email. Someone saying you shouldn't do that. And it's really, really helpful to have someone on your team, whether it's a colleague, maybe a supervisor, but just even a peer to say, hey, thinking this through. Here's my process for thinking it through. This is what I think is responsible. It's aligned with our mission. It makes sense under my understanding of law. And I'm going to do that. And so, like, does that make sense to you too? So, like, if you get a nasty note, like, are you on board that, like, this is a reasonable thing for us to have done? You know, that's the first step. And then if you're like, okay, yeah, I think there's a small chance someone's going to send us a nasty email that says you shouldn't do this. And if it does, we'll deal with it then. We can take it down. We can do whatever. We can do a little more research. Have a little team. Have a person you make your decision with. And then if you're doing something where you think you could actually get them to someone who's going to write you a demand letter, right? Which is the next step up. A demand letter is when someone at a law firm writes you an email that says, you are infringing copyright, you are violating this license, we're going to sue you. It's important to know that having written that demand letter, they don't have any obligation to actually intend to sue you. They don't have any obligation for that letter to be what they think is a neutral, honest statement of the law. So people can write demand letters for things that are absolutely legal. They do it all the time, right? Like if I wrote a newspaper article that said, you know, I think I don't know, I'm trying to think of something easy. So like I wrote a newspaper letter that was like accurate, but the book review and I included a couple of quotes and like, you should take this down. We're going to sue you for defamation and copyright infringement. Everyone knows that you can write reviews that things that are not flip-flottering about the book. Their lawyers don't think they're going to win. They could still write that letter, but they stop them from doing that, right? There isn't this like, it is not a part of the sort of ethical code of legal practice for you to be neutral to the other party. You're allowed to state your case as aggressively as possible. And so when you get nasty letters where they're never going to sue you, they don't think they're going to win. They just want you to stop doing what they're doing. And so that's a question. It's like, could your professor tolerate that? And then there's the third case where you're like, yeah, they might sue us, but I think we're right. And I think we're going to win. And so in very few situations are people actually willing to tolerate that. Even if you're right on the law, the idea of being sued is too negative, right? And so that's why this question of risk has to be decided by the person who's going to go through the thing. There are a few people in the copyright world we live in who are like, yeah, definitely sue me. I'm right. You're wrong. I don't want to get pushed around. But that is sort of few and far between. So most people fall somewhere on the go ahead, sue me to, okay, if I get a nasty email, but nothing else, I can tolerate that. And so you have to figure out sort of where your advice receiver has to decide for themselves what their question is. So it's a long answer, but does that sort of answer your thing? Which is, I think, published. But the most important thing for you to try to give the whole range of neutral things and say, like, what do you want to do? Like, you know, here's what I think, but they need to make that choice.
Okay, so kind of just, as you said, like neutrally maybe argue it both ways.
I mean, I think tell them like what you think the risks and benefits are, right? So I think that's the whole point of giving people information is you have to say, well, it's always a little bit hard to make analogies to other professional fields, but like, you know, I think the answer is here, you want to give them what you know about the law. And then at some point you can say, I think I give advice probably a little bit more on the margins. Like if something is like clearly, like someone's like, hey, I'd like to make an open education textbook by taking chapters from these 3 proprietary textbooks and mashing them together. And like in that situation, to be honest, I'm like, I don't really think that's generally fair use. Like I don't think that's something that's really supported unless you have some special case about why this new textbook you're making is really like transforming those materials and not just copying them. So there, I give the bottom line, which is like, I don't think that's usually fair use. But I leave open, like, unless you're doing something really different, and we can talk through that more, right? So like if you're making a textbook about the history of science, using a bunch of science textbooks and using chapters for examples about how things have been taught over time, yeah, you could do that probably. But if what you're doing is just saying, hey, I'm taking these 3 biology books that are all like closed proprietary biology books and I'm taking a couple chapters each, I'm like, yeah, generally I don't really see good arguments for that. So like, unless you have a different thing, but that's a really like clear case. And the other side is true. If someone comes to me and says, hey, I really want to use this 2-sentence quote from a novel in my OER to remind students what quote we're talking about, I'm like, well, that seems very low risk to me. Like, unless you have some reason to believe that this is going to draw really high critical scrutiny, I wouldn't worry about that. But the middle is almost is going to be try to give them the information. You can say like I might end up here, but I'd be a little careful about that because you're generally in the same sort of pedagogical or mission as they are, and it makes it hard to make those decisions. So I saw another question in the chat, but I've lost it.
Hold on. I'll give you that one in a second, but I wanted to take some privilege and jump in here for a second.
Sure.
If it helps. So I was an academic librarian and a public librarian. And I think one of the difficult things about answering questions like this is that, you know, a lot of times, you know, like a faculty member is coming to you, often they're in a hurry, or often what they really want is a quick answer or something, an easy answer. And unfortunately, like the law is not typically very black and white. Legal questions often do not have super easy answers, and copyright questions. So, you know, I will often find myself explaining this, like, you know, because there's a lot of kind of rules of thumb and misconceptions out there, especially about fair use. So I would hear things like, oh, well, if I just photocopy 1 chapter of a thing, then it's okay. Or 10% of a thing, then it's okay. And there's, you know, nothing in US Code Title 17 in the US anyway, a copyright law that specifically says 10% of a thing is okay. So it's
right.
really, you know,
Many times the whole thing is okay. Many times 10% is still too much.
exactly. So people always get a little disappointed when I kind of crush their hopes and dreams about having that sort of simple answer. But one of the things I will do when I'm kind of answering legal questions is actually very similar to what Sabrina just put in the chat. So Sabrina says, notes that they often encourage people to kind of write out their thought process or make a good case for doing something. And I'll leave that question for Meredith in a second. But this is kind of what I try to get people to do. Is, you know, they'll explain to me their situation, they'll explain to me what they want to do, and I'll try to focus in, first of all, on what their goal is, like Meredith said. Like, you know, is this the absolute best resource for you to use pedagogically? Because the simplest answer is often, you know, is there something openly licensed you can use instead? Is there something that has very clear reuse terms? Because if there is, then let's just do that, and let's just avoid this thorny issue entirely. But sometimes, you know, the answer is no, this is really the thing I have to use. And so then I'll start asking, you know, if I were in your shoes, these are the questions I would start thinking about. These are the kind of the most pertinent things I would focus on. So I would start asking myself, you know, is this, you know, the absolute best thing? Is this the thing I have to use? Am I using, you know, exactly the amount I need in order to make my educational point, and, you know, not using any more or being gratuitous about it? And you can kind of like walk them through a little bit of that process. With the other recommendation I had, and there used to be a really nice tool for doing this on the internet, and it is gone now. There are some checklists and things I'll let you all Google. But one thing that I have heard is similar to Sabrina's question, is to, especially in like fair use evaluations, is to document kind of your choices and your thought process. So especially like in cases of orphan works, you might have If you're in an archives, you'll often have a file already started that has like an MOU or some provenance from how you acquired the thing in the first place. You can stick it right in that file. Like, we chose to digitize and share this online, and we think it's a fair use because of the following things. You know, we kind of thought through, this was our process. And then 10 years down the road, when you don't work there anymore, and somebody comes to the library or the archives with a complaint, um, it just helps you in the future, or it helps your predecessor in the future, your successor, sorry, to be able to say, okay, you know, we didn't just do this willy-nilly. We did kind of think through these things. So they have a better understanding of kind of what your analysis was at all. The part that I don't know the answer to, that I'm going to throw to Meredith right now, is, does kind of documenting that thought process actually have like legal value? Is it useful in court? You know, if something does happen, is it a good idea that I did this, or is it just kind of a best practice we talk about in library land because we like documenting things?
So I would say it depends, because I'm a lawyer and I'm contractually obligated to do that. But more specifically, there are types of documentation that are good, there are types of documentation that are neutral, and there are types of documentation that are bad. So types of documentation that I think are good is, you want to be honest and clear when you are using fair use. There is no benefit at all to anyone in you not being clear when you are using things under fair use, right? Like, you need to be, especially the OER space, right? Because in OER, you're asserting everything under this license I've created an IM licensing. So if you're including things that are under fair use, you need to mark those, right? You need to be clear that those are not under the license. And in general publication, you don't have a legal requirement to mark them, but when we did the best practices in fair use, people feel pretty strong there's an ethical requirement to be clear. In your monograph that you were talking about, with this person published these letters, like, that might be clear from the introductory material that this is fair use. Like, I don't think you need to have formalism about that marking, right? Like, if you're writing a textbook and you include like a quotation from a book, you don't need some extra special fair use marking. Like, the whole marking of the quotation and whatever is already there, right? You don't need to do any special legal marking. This isn't like the CC title, source, that marking. You just need to have it be clear to the reader what stuff is yours and what stuff is not, right? And that can come in lots of different forms. That's really important. The second thing that I think is really important, along the lines that Shanna was talking about, if you're going to do extra documentation, particularly in cases where it's not really clear from the resource itself, is talk about your pedagogical and mission purpose for that fair use, right? And so this is the area of documentation that can be really legally valuable. So if you're using, one example that I will never forget is, we were talking to a bunch of folks about including a read aloud video of a children's storybook in a high school English literature class, right? And so the children's storybook was called Henry Hikes to Fitchburg. And in the children's storybook, it's like the story is a sort of includes these like analogies and sort of references to On Walden Pond. And so we were talking through, like, okay, students are reading the book and then they're listening to this read aloud to try to identify where the themes from the book are surfaced in this read aloud, right? And so we were going through the process, and I was like, just asking questions. And I was like, why is it important to include the whole thing? And one of the teachers was like, well, you have to use the whole thing because the students' like exercise is picking out pieces that come from the novel. And so if you don't include the whole thing, the picking out piece isn't really a pedagogical task anymore. And I was like, oh yeah, that's very true. And that's the sort of thing that it's super helpful to write down, right? It's really helpful to write down your pedagogy. Why is this thing different than the other thing that was created? Similarly, if you're creating an OER where you include front page images from a newspaper, maybe you include front page images from the New York Times for the last 100 years to show that like the way we cover politics has either changed or not changed. And so you might include those, and you might include you might be like, using the New York Times stuff is sort of risky because like they're big, they have a lot of lawyers. I want to make sure I really make this case clear. And you're like, okay, I included these front page images to illustrate the ways that we've talked about war over the last 150 years have changed, but the ways in which we've talked about like domestic politics haven't. And so these examples really clearly show how we've talked about presidents like in this way in these three examples, and they show X, right? That's the type of writing that you absolutely should do. And you should do it that way in a chatty, descriptive way that can talk about lots of materials at once, right? You're talking about like maybe 10 different front page things. You don't need to write a different like check the box form for each one of those things. That's actually probably worse. You're talking about the relationship between them. And so that's really important. And you could write that maybe for a whole lesson, maybe for a whole textbook, even if you're using stuff for similar reasons. And it talks about your pedagogy and your very specific purpose. What you do not want to write is, I am using this for an educational purpose, or I am using this for critique. You want to talk about, like, actually, if you were explaining to another teacher in your discipline, why these things? And the reason you want to do that is it's what you're an expert at. It's the piece of information that you can put in the record right there that you know better than anyone else. It is not particularly useful for you to put in your fair use legal analysis. I would generally recommend do not do that. Do not write, this is transformative because of X and Y. That's a thing that it's better to let, should this ever, like, I know of no instances in which fair use in OER has ever been litigated, literally zero. Because the chance of you getting sued over fair use in a good faith educational context is not absolute zero, but it is close to absolute zero as you can be, in part because there is a provision in the law that says good faith mistakes in fair use by nonprofit institutions are limited to actual damages. So like there's nothing to get. Like the chance of this getting litigated is vanishingly small. So there are no cases. But should you get sued, you want your lawyer to be the person who gets to make the argument of how we think about fair use. What you want to do is be very, very clear about what you were doing, because the core question in fair use is, how is what you're doing here different or transformative as to what the publisher did originally, right? And that's a really easy, that's the first question in fair use. Is it transformative? And that's a really easy question to answer if you've been really clear about your specific pedagogical purpose, because almost nothing out there that you're going to use from third-party stuff in real books and movies and newspaper articles and whatever was created for the pedagogical purpose you're using for in the classroom. So you want to just be really specific about that, right? Write that down. And it can be in the materials or it can be in your file. That's the sort of stuff that's really valuable. The stuff that's not very valuable is the checklisty stuff where you go check education, check critique, check transformative. Like that, the checklisty stuff is almost worse than nothing, because it can make it seem like it wasn't actually sort of deeply analytical, that you just literally sort of checked the box. Similarly, it's way better to have something that's thoughtful and written out for a big bundle of sources that you're using under the same theory than it is to have a sort of checkbox thing source by source. And that's the other part, I think, is that, you said coming into this, Jano, entirely correctly, people want, they want just the like, tell me yes or no so I can move on with my life. But what I will say is, at least in the context of folks who spend a lot of their time creating OER, in fact, the situations you see are going to be repeated over and over again. And you will get to the point, like if you teach art history and you spend all your time figuring out, like, can I include these images, or can I include, you teach media studies and you're like, can I include these clips? That the first couple of times you do that, that's going to be hard. But eventually that's going to get easier. And you get to the point where you're like, yes, yes, no, maybe. Like, and that's the thing that if you do it over and over again, I think the other check is, we're saying talk to folks about their purpose. And the red flags you're looking for are if their purpose is just, if the purpose isn't really different than the purpose of the original, that's the red flag. So if they're like, I want to just Xerox these 3 chapters of this textbook because the textbook's too expensive, but otherwise my students would definitely buy and use this textbook, well, that's not really a different purpose. If the purpose is, I want to copy this 1 chapter of this book on a really different subject because my students aren't learning to be mechanical engineers, but they do need to read this 1 chapter about machine construction because we're learning about like industrial development or whatever, then yeah, that's much more reasonable. So it's not about amount, it's about purpose. And that's why getting people to write about their purpose is really, really important. And it's like I said, it's the thing that they know then in that moment that you can't reconstruct later. And so if they write a good, clear, specific purpose statement, and specific to the purpose, not to the object, right? You could write it about 10 articles if the analysis was, it's better to have 10 good sentences about 10 articles than 1 pro forma checkbox for each article. Does that make sense? But yeah, so that's a really in-depth answer to that. It's taken about 40 minutes of our time. So there's a couple other questions in the chat that I wanted to make sure we got to.
Yeah, I've got 2 on deck. The one from earlier in the chat, and thank you, Jaina, for patiently waiting. They noted one question they get as a librarian is, I want to get this published, but I want to put it in a repository as well. Am I allowed to do that? And usually this participant tells them to refer to the author agreement they signed from the publisher.
Yeah, so that's a question that's like a very hot topic among scholarly communications librarians right now. And again, that's going to come partly to the law and then partly to risk tolerance. So like, unfortunately, for better or worse, in US law, we allow you to contract away a huge amount of stuff. And so if you sign a contract that says, I will not publish this in any form in any other way, it's a question of whether the repository will count for that I can't answer. The other answer is the publishers don't have any like obligation to publish you, right? And so if you put something in a repository and they're like, no, we don't want it. But what I would say is that is a question for like the scholarly communications librarian networks. Like there are people who spend their whole career doing very, very like clear work on that. And I'm just not a scholarly communications expert specifically. And so my answer would be to get involved in the different scholarly communications librarian networks. Find if you're at a smaller institution that doesn't have a dedicated ScholComms librarian, I really encourage folks to think about like regional collaboration. Like, is there a big research university near you where you can be like, hey, I don't feel like I have a lot of support, I have some questions I'm trying to think through, would you be willing to talk to me about your practices, right? And that's another thing, you're not asking them for legal advice, you're like, hey, could you talk to me about like your practices, but what you do? And that's a little bit scary for everybody because it's scary to tell people this is what I'm doing in case someone's like, hey, you're doing this wrong. But I do think if you come in, you find someone for whom you have some shared context and just be like, would you be willing to talk to me about what you do in these situations? That's how I would address that. And I am just not a scholar. Like, there are probably people in here who know more than me about scholarly communications. And those are always sort of the boundaries of those are being pushed. Like, there's a big debate right now because the federal open access policies are going into effect. And some of those have what appear to be conflicts with some of the publisher requirements. And so publishers are saying you have to go gold OA and pay this article processing fee, but then they've recently come out and said, actually, we're going to cap those fees. But the answer is, don't be hesitant to ask people. So this is like a lot of other stuff. You can ask people who are expert on this for help, as long as you're not asking them, like, it's like when you go to a job networking thing, you got to be like, hey, are you willing to talk to me a little bit about this field, not like, will you hire me? Like, that's too intense a question. And so I think one of the ways to think about this is you can definitely find people who are experts in these scholarly communications areas and be like, hey, would you be willing to talk to me about how you think this through at your university? Or are there resources you'd look at? Not, will you tell me what to do? Because that person's going to feel like they probably can't tell you yes, definitely, no, don't. But look for those information.
Yeah, exactly. I was a scholarly communications librarian for a while. And even then, like a lot of my, when I talk to folks about these questions, a lot of it is sharing resources and plugging them into communities. So I was just going to throw out there, if there's anyone on the chat who isn't plugged into some of these scholarly communication communities, there are some listservs, there are some Slack spaces, there are some other stuff. Do feel free to reach out to me. I can always kind of connect you with the ones that I know. And that can be a great place to kind of get helpful advice. I'll also just put a quick plug in for those who successfully complete the CC certificate. You'll be invited to join our alumni network, which has a listserv, and we meet a few times a year. And that can also be a great place to just get information and ideas and advice, right? Like, I'm having this strange situation at my institution. Has anyone else had this situation before? What did you do? And when it happened to you, what kinds of things did you think about? What kinds of resources did you use? And you can kind of share ideas that way and see if there might be resources out there that work for you too. Next on deck, I have Christian noted that they have a question. So I'm gonna open the floor if you want to unmute.
Yeah, so I'm not a librarian, I'm a musician over here. And in preparing for my final project, I've been doing research into print scores using different CC licensed works. This is for sheet music. And what I've discovered is that one, the orchestral music is not adapted to be played in the orchestra. I or somebody else would have to adapt it to make it usable in the orchestra. And the other issue that I've come across, I'm a Bach expert over here, and I happen to know that a lot of 19th century scores are not correct. And I can eyeball them and say that these are added notes. This is what we call addition issues. So I go through and I fix these problems. I'm sort of the person in my circles, both amongst the jazz musicians and the classical musicians that I work with, that say even these scores that are otherwise in the public domain have to be adapted by somebody. And it represents somebody's work. Even if it's Beethoven or it's Bach or somebody put the work in like I did to adapt it for orchestra. Somebody put the work in doing the research on Bach and saying these notes are not correct. This is not what Bach actually wrote. And I'm considering using CC licenses, but based on what I'm hearing, I'm thinking of putting what would be called a position statement. And this is my question, is it correct? About saying something to the effect of what I've just said. If I were to put a CC license and stuff out there, just to make people aware that it represents my work and my investment. Somebody put years and hours into studying the stuff in order to make this available to the public. Does that fall under a position statement?
So I think there's a couple of different things to untangle there. First of all, one of the weird, unfair things about intellectual property law is that it tends to reward certain types of effort, but not others, right? And that is a weird, unfair thing. So intellectual property law only sort of indirectly rewards or protects research. So if you go out and you do years of, painstaking field research where you do social science or anthropology research, and you go to different places and you collect sources and you get information and you trace, you bring new factual information, surface new factual information in the world. Maybe you do like archaeology, maybe you do this things, you get this new information. You have like, oh, you know, we actually now have evidence that these people lived here and did this thing, or we now have information about this, the history of this thing. The facts of that, even though they are really hard to get and really valuable, are not protected by copyright law. So the book you wrote about that would be protected about copyright law. But someone else could write another book with all of those facts, even though they hadn't gone to the places and done the research. And professionally and ethically, they would need to cite to your research. And they could very appropriately maybe not get a reputable publisher to publish their book if they didn't do that citation. Or they would get, you know, not published in scholarly journals. But from a copyright law standpoint, they could publish a book that had those same ideas as long as it had different words. And so you see these sort of two systems working in parallel. The professional system that says, no, you have to attribute, no, if it's not your own research, you need to give credit to where it came from. And then you have the copyright system, which only really protects expression, not ideas. And so some of your stuff, I think, would fall into the two different sides of that category. So in the situation in which you were correcting errors, my guess is under US copyright law, that probably isn't a new separate creation. But that could be a really useful situation for the professional norm, right? At some level, statements that are about sort of intention or use or preference are statements that bind other people in your professional community or bind other people in with whom you are in community, right? They say, hey, this is what I'd like you to know about this. And I think those can be really useful across all sorts of stuff that are published with an open license. You might say, if you find other things that you think might be an error, contact me. People in OER often say, if you've made use of disrupted it, please let me know. Just like I'm curious what people are doing. And so I think that would probably be in a preference statement. It's possible that, strictly speaking, you would publish music that had been corrected, but to which had not been otherwise sort of re-authored or reimagined. That might be published. I might talk to someone about publishing that under a CC0 license, because I'm not sure there's a new copyright in that, even though there's a lot of new effort. But you could still keep that statement about preference and provenance there. For the orchestra, for the translating that music to the appropriate format for orchestra, that is a artistic process that I do not know enough about to probably give you really precise information. But one of the things we think about that may be a useful analogy is works in translation. So when you have a work in translation, there is a copyright in the original, but also a copyright in the translation. And in that situation, even though there is no copyright in the original, it is possible there would be a copyright in this translation, if translation is a meaningful analogy, to orchestra. And that is something that's something you would have to ask somebody who knew a little bit more about music copyright than I did. But that would be an interesting analogy. And in both of those situations, I think the statement about credit and attribution makes sense, and you should write really whatever you want about your project and your work and how you want to get credit and how you there, with the caveat that, you know, the whole reason that some things are set aside from the license is that they are about the functioning of the community, but not sort of legally enforceable against someone who is sort of adverse to you. And that's always going to be true. With the added caveat that the licenses are only sort of, people focus a lot on enforceability, but the number of people who have sued over the terms of the CC license measures, I think, in the probably all told in the hundreds, but not very high up in the 20 years the licenses have existed. So, you know, I think it's a lot more important to think about clear communication to the people you are in community with.
Awesome. Thank you, Meredith. We only have a few minutes left. So we probably have time for one, maybe two more questions. And so I'm going to jump to a question that's a little bit different than some other stuff we've talked about so far. And if I don't get to your question today, I'm going to add it to the document and we'll get to it next week. So there's a question about, is there a risk of getting sued if you publish positive reviews of something, even if it's for commercial use? So for example, an article in a magazine about the 10 greatest album covers where you print the album covers. Like, do magazines pay fees to use content like this, or does it fall under an
A lot of that is
exception?
just sort of like customary commercial practice. So the answer is like generally no. But that it just depends on like field and whatever. That really comes down to like, for better or worse, you will never get out of the risk box, right? And I just can't imagine a situation personally in which. So I think that, like, if I were trying to figure this out in a situation in which you were just trying to think about, does the other person want this or not, right? So there's two separate questions. One is the fair use question. Is it fair use to use the album covers to refer to those things, right? In which case it doesn't matter whether they like it or not. Really. I think you can make a good argument that it may be, right? That it's sort of a nominative fair use. This is a reference to the thing, right? The second is, does this person have any possible interest in suing me over this, right? Because you're never going to be able to separate the law from the risk. And so like that seems to me like a very low risk thing. I think a use of covers that might seem high risk is a situation in which you were selling if you were selling something that was like exercise routine inspired by this top 10 album, and you use the picture of the top 10 album on the cover, so you're really getting this commercial benefit from the album's name, right? Whereas if you're writing an article that's just to the albums, like you're not getting some like huge commercial benefit from that. I don't know the license it out. Yeah, those are not licensed just because transactionally be a huge pain in the neck. My guess is they send them an email and say, hey, we're going to feature your article, send us the image. But the reality is that the formal publishing world is much more just sort of commercially pragmatic about what they do and don't pay for. In some ways, I think folks in the CC world are actually like much stricter because they're sort of focused on this, like, I really, really want to do the right thing. And the publishers are sort of like, I just want to get to next week, you know? And so there's stuff they pay for, there's stuff they don't. But my guess is that's not generally paid for.
Awesome.
And then the question of like, is there a risk of getting sued? I mean, idiots can sue you for anything. It's not likely though, right? So no one's ever going to tell you, oh, there is zero risk. The answer is never zero. At the same time, you have to be like, in what world is it actually worth it to someone to spend good money? People say you can sue over anything, and that is technically true, but misleading. You can, but it is expensive and time consuming and hard. And there are many checkpoints in the process where if you don't have a good case, you will get thrown out. So if your risk tolerance is, I cannot do anything for which you can construct an imaginary scenario in which someone can sue me, you should stay home. People can sue things over, you know, but they don't. They can. But in practice, mostly what happens is you a nasty note over anything. And you have to build up a little tolerance for nasty notes. And they can do that under CC. Like, there is no magic defense against that. Mm-hmm. There's one more question here about there's two questions maybe I want to answer quickly. One is, if folks are creating OER, should they document their thought process? I would say yes, but only in situations in which they feel like they're actually making a new or difficult choice, right? Like, I don't think there's some huge, I would discourage folks from creating a sort of very formal, everything has to be documented. And I would encourage folks to say, if you're doing something that you think later people might want information about, then yeah, write that down. You know, I think if you're publishing OER that fair use materials, write a couple sentences, you know, mark those as fair use in the published material, and write a couple sentences about your analysis for your records, right? We're using these sources because they show this point really well. You know, they were originally published here. We're now using X. I think that's good. And it lines up with that second question, which is, what are the pedagogical questions to ask faculty? And I think that in a friendly amendment, it doesn't have to be the best material. It has to be like, why is this the right thing? Why is it a good choice? Not like, why do you have to do it? And I think a lot of that comes into like, what's the role of authenticity, right? And I think that's particularly poignant right now as we look at the debate about AI materials, about the sort of meanings of like, if this is content that we need to be authentic, to be about human experiences or experience or data or whatever, that's often something where if there's a real need for authenticity, there's also a need for fair use, because you cannot sort of recreate those authentic cultural or documentary materials under an open license after the fact, right? The music and books and movies and those things were published out there in the world, almost always not under a CC license. And for those authentic things, you often need for use. And then you have stuff for which you need careful expert, authorship. And that's a thing for which open license materials are really good. Someone's an expert on biology, they write a biology book. And then this third category of like, yeah, I don't know, I just need a document, like I just need a picture of a frog jumping from this fake lily pad to that fake lily pad to illustrate distance. That might be a fine use for AI, right? Like there's not a lot of need for careful factual analysis, and there's not a lot of need for authenticity. So maybe that's that third thing. But so I think in this moment, the sort of parsing out, where do we need fair use for sort of cultural and historical authenticity? Where do we need CC licensing for sort of careful, reviewed expert attention? And then third bucket of sort of decorative or illustrative stuff, one in which people use AI. Thinking through the pedagogical purpose of like, why are you doing this is going to be really important to think about those buckets. So we are 3 minutes over time, but this was really useful. And sorry if we didn't have time for other questions, but I hope it was useful to you all. And I think that you will do great.
Yeah, thank you so much, Meredith. Really appreciate you taking the time and a little bit extra. Folks, if you do think of other questions after we sign off today, or you have follow-up questions, we do have a second session next week with another legal expert. So you can please put those questions into our legal document, into our advanced questions document. That's what I mean, which I will put in the chat one more time. So yes, thank you again for taking the time, Meredith. Please go enjoy the rest of your day. Thank you all for being here and for asking such great questions, and we'll see you soon.